The topic of my article is the penalty clause, means of guaranteeing the execution of obligations. The penalty clause is an important mechanism in civil contracts to protect the rights and interests of the contracting parties if one of them fails to fulfill its obligations. In the Republic of Moldova, this provision is regulated by the Civil Code, which sets out the conditions and limits under which a penalty clause may be included in civil contracts. A penalty clause is a contractual provision whereby the parties assent the loss in advance, stipulating that the debtor must pay the creditor a sum of money or other property in the event of non-performance of the obligations. The purpose of this article is to analyze the regulations of the penalty clause in the Civil Code of the Republic of Moldova, to highlight its importance in civil contracts and to examine the conditions under which it can be applied, as well as its limitations and legal effects. Introduction. In fact, the penalty clause represents an advantage for the creditor, avoiding the judicial assessment of damages. The creditor not being obliged to prove the existence and the extent of the damage, or even to receive the penalties without any damage suffered. In order to obtain payment of a penalty clause, he only has to prove the fact of non-performance, improper or late performance. In Moldovan civil law, penalty clause is a form of contractual liability that can be included in a contract, and its purpose is to protect the interest of the parties to the contract and to encourage the performance of contractual obligations. The penalty clause can be included in any type of a civil contract, such as sale-purchase contracts, rental contracts, or service contracts. According to Article 948 of the Civil Code of the Republic of Moldova, the form of the penalty clause is drawn up in authentic form if the law requires authentic form for the legal act to which the clause applies. In other cases, the penalty clause shall be drawn up in writing under the penalty of absolute nullity. For a penalty clause to be valid, it must fulfill the following conditions. It must be set out in writing, it must be proportionate to the seriousness of a breach of the obligation, it must be provided for in the contract or in the contract supplement. Under Romanian law, the statutory penalty clause is regulated by the Civil Code and can be included in contracts under the following conditions. The penalty clause must be proportionate to the value of the main obligation set out in the contract. The penalty clause must be expressly mentioned in the contract. The penalty clause cannot be used to compensate for actual damages suffered by the injured party. According to the Romanian Civil Code, the court may reduce the penalty in the following cases. If the amount of the penalty is excessive or disproportionate to the damage suffered by the injured party, if the party who breached the contract tried to remedy the breach before being sued, whether the breached party had reasonable grounds for the breach, whether the penalty was paid in part or in full by the party in breach of contract. Functions of the penalty clause. In contractual relations, the parties have a possibility either in the contract or by a separate agreement made after the conclusion of the contract but before the damage occurs, to determine the amount of damages due by the debtor as a result of non-performance of the contract obligations. The function of guaranteeing the performance of obligations by the debtor. These functions, although not regulated by law, arises from the practical reasons why this type of clause is inserted in contracts. The insertion of a penalty clause makes it a legal means of putting pressure on the debtor. The debtor's mobilization function in the performance of contractual obligations. By its drastic nature, the penalty clause is a means of mobilizing the debtor to correct contractual conduct in order not to expose himself to the negative consequences arising from the implementation of this clause. The penalty clause becomes mobilizing for the debtor when, in the event of non-performance of the obligations, at the time or in the place agreed, the creditor requires the debtor to perform both the principal obligation and the penalties. These functions of a penalty clause is particularly evident where the amount of a penalty is greater than the amount of the damage causes to the creditor by the non-performance, improper performance or late performance of obligation to which the debtor has agreed. The sanction of the penalty clause. The penalty clause penalizes the unlawful non-performance of obligations by the debtor. Thus, the penalty clause is a private contractual penalty. According to this function, the penalty clause is due irrespective of the existence and the extent of the damages causes to the creditor. The compensatory evolution and the reparation function. The reparatory function, also called the compensatory function, is the most important function according to most legal doctrine in our country. The purpose of the penalty clause is to make good the damage suffered by the creditor as a result of the debtor non-performance, defective performance, or late performance of the contractual obligations. Legal characteristic of a penalty clause. From the legal provisions, we can deduce the following defining legal characteristics of a penalty clause. It is a contractual clause, is accessory, is solemn. Operation of a penalty clause. As regards the operation of a penalty clause, it becomes enforceable when the conditions of the debtor's contractual liability are fulfilled. And conclusion, the penalty clause is a contractual provision whereby the parties agree that in the event of non-performance of the contractual obligations, the party in breach of the contract shall pay a sum of money by way of penalty. This amount does not represent the actual damages suffered by the party who suffered the loss, but is a fixed amount provided for in advance by the parties, which is intended to discourage breach of contract. There are different views of the usefulness of a penalty clause in contracts. Of the one hand, some argue that the penalty clause can be useful in situations where it is difficult to determine the actual damages suffered by the injured party and can be a means of deterring breach of contract. On the other hand, others consider that the penalty clause may be excessive and may be a unjustified sanction which can be used by one party to intimidate or put pressure on the other party. It is important to note that the penalty clause is only legal if it's explicitly stated in the contract and is proportionate to the damage suffered. Otherwise, it can be considered unfair and can be annulled by the court. In conclusion, the penalty clause may be useful in certain situations, but it must be used with caution and must be proportionate to the damage suffered. It is important to set out the contractual provisions clearly and avoid any ambiguity or uncertainty that could lead to misinterpretation.